It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my forgiving co-host, Brett.
Oh, thank you, Alice. It's so good to be back. And yes, if I'm going to be friends with you, I have to be forgiving for all the terrible things you do to me. But I keep coming back because that's how much I enjoy your company.
Well, you've been very forgiving in all of my stories about my minivan.
I love your minivan. It's amazing.
I do love my minivan.
What do you call it
for
again?
Sure.
You need to share that with everybody. The Hodacy.
My Hodacy.
Love it.
Because it is so hot to just decide not to be hot anymore and drive a minivan.
Yeah, well, I don't know. Once you got 3 kids, it's hard to pack them all into the car, right? So,
well, they really frown upon you like putting a car seat on the top of your car and strapping it down with cables. Yep. I hear that it's not code or something. So we had to get a minivan that
regulations, man.
Regulations.
Holding you
the
down.
Government. Speaking of the government.
I
wasn't really talking about how forgiving you are at all, because really you're not forgiving. Everybody knows that you have a lot of snark. In fact, it ties into, imagine that, something we're going to talk about today, and that is a super non-controversial, super boring topic. Student loan forgiveness.
That's right. We went through the entire Supreme Court term and we haven't talked about any of the cases. Last year we did a whole bunch of cases. This year we hadn't done any. And so we wanted to do some. And what's interesting about this one is it's one of those things where the subject matter is close to a lot of people's hearts. A lot of people, most times people don't pay that much attention to the Supreme Court. I mean, they might read articles about it, might get mad about it or whatever, but it's rare that it directly affects as many people as this case did. And it's super interesting from a legal nerd perspective. So it seemed like the kind of perfect case to talk about. It is Biden versus Nebraska, if you want to read it. And as Alice said, this is all about student loan forgiveness. As many of you may know, and as many of you may have been following closely, at some point, I guess about a year and a half ago or so, the Biden administration proposed a plan, enacted a plan, in which they were going to forgive a certain amount. I think it was $10,000 per borrower. $10,000 per borrower if you had federal student loans, if you made less than a certain amount of money. So it was a pretty big deal. Depending on who you ask, this is several $100 billion, maybe even up to $1 trillion over the lifetime of these loans. And there were a lot of borrowers who were going to be impacted by this. Well, the problem is that money, it's coming from somewhere. A lot of times these things are actually handled by these sort of loan servicing companies, which you've probably dealt with if you're out there and you have student loans. And so some of them, along with some states, sued to prevent this from happening. And it went all the way to the Supreme Court in a case called Biden versus Nebraska. And at the end of the day, in a 6-3 decision, the Supreme Court said the president doesn't have the power to do that. And that was sort of the headline. I mean, the headline for most people was just Supreme Court blocks student loan forgiveness plan. But why it did it is actually pretty interesting, and I think raises a lot of questions about exactly how power works in the federal system. And I think if you can take yourself outside of the student loan thing, which may be difficult if this personally affected you, is one of those things you can sit around and think about how exactly do you want it to work. And you have two really good opinions, a good majority opinion and a good dissent. You can read them both and see sort of the reasoning, and the reasoning of the two opinions define a lot of the arguments that you see in the courts over power. So that's why I want to talk about it, because it's an interesting case, but it also is a case that affects a lot of things. And as you're watching sort of not only Supreme Court cases, but cases in the lower courts in the future, I think having an understanding of the way courts look at this would be helpful for everybody.
Yeah, absolutely. And I know you guys have probably all read articles about it and even have thoughts about it. But the great thing about this case is it really goes to the core of the Constitution, right? In terms of the separation of powers. And that's what Brett was saying when he says this case is a great case to really dissect how we want the separation of powers to work and how it does work. And separation of powers, for those of you who may not be American listeners, we have three branches of government and they have defined roles, and we have checks and balances where one branch doesn't have all the power to do something. So that was to kind of shield against any sort of a dictator or a royal, like a king, since the founding of America was because of separating from a king in England. And so it's a very interesting conversation that has existed since the very founding of this country. And that itself is something that we should all know about. So if you don't know that this is the core of this case, we're really glad you're here. We're not here to debate politics. We're here to debate the Constitution.
And for those of you in other countries, or maybe if you're in the United States and don't really understand how this works, so education is expensive, and it's been getting more and more expensive over the decades. And there's sort of one of these ratcheting problems. Your parents probably talked to you about how in their day, they worked part-time and paid for college. Well, you can't do that anymore. And there's a couple reasons for that. And one of them is colleges have a lot more amenities now than they used to. And it's a lot, when you got the pool with the slide, which, I remember when they put the slide pool in Alabama when I was there, and it was a big deal. And a lazy river, it was a big deal. But guess what? You're going to pay for that at some point. And because the federal government forces you to take out loans with them first, loans that are guaranteed and loans that you're required to pay back, basically death is the only way you can avoid them. You can't, if you go into bankruptcy, one of the things that's protected oftentimes is student loans. So you're just on the hook for them for forever. And basically we take 18-year-olds who we don't give a whole lot of responsibility to, and we say, hey, yeah, sure, $250,000 of debt right out of high school. That's great. You should totally do that. And this has led to a lot of money. Students have a lot of money because they can take out loans, and universities continue to raise the prices because they know people will pay. And you've got this just sort of spiraling problem where education just gets more and more expensive, which means you have to take more and more loans out. And because one of the other things you see is more and more people going to college, oftentimes the college degree isn't enough. And so then you end up taking out loans to go to graduate school. And by the time you get out of school, you can find yourself under a weight of loan debt that you may never be able to pay, particularly given your profession. If you have a profession where you're not making a ton of money, that debt can be something that really weighs you down. When I went to law school, I took out private loans and public loans. I paid off my private loans last year, and I had my public loans forgiven, and we're going to talk about that in a second, because I will say, bad incentives. When I was paying back my loans, I paid back my private loans as much as I could pay at the highest rate possible. My public loans, I paid back at the lowest rate possible, because I kind of felt like eventually some sort of student loan forgiveness thing was going to happen. So I kind of hedged, like they're never going to forgive private loans, but one day they may forgive government loans. And sure enough, they did. So I think that was a gamble that I called correctly. But this is sort of a bigger picture thing. Faced with trillions of dollars in debt, there have been a lot of discussion about what do you do about that. So in 2022, President Biden, under the purported authority of the Higher Education Relief Opportunities for Students Act of 2003, the HEROES Act, canceled an estimated $430 billion of federal student loans, which, given interest, as I said earlier, is probably closer to $1 trillion over the time of the forgiven loans. This would have completely erased the debt of 20 million borrowers, while significantly reducing the debt of 23 million more. Now, what's interesting about this is the HEROES Act was passed all the way back in 2003. And it's not until 2022 until the president decides, I'm going to use this to do this thing. And that is actually something that's going to come up. You have a statute that's been around for about 20 years. And we've had a student loan crisis for that long at least. But no president up to that point had ever thought that statute gave him the power to do this. But President Biden in 2022 decided that he did. And once he did that, 6 states and several private actors sued. And they alleged that this action went beyond what the HEROES Act allowed.
A couple notes on this. Every single statute has to have some great acronym. The HEROES Act, like this one. And having worked in Washington, D.C., it is the bane of like a lot of interns and staffers many nights of coming up with a catchy acronym for your act that, because I mean, it really does work, right? When you have a great acronym, HEROES, who wants to be against a HEROES Act? It sounds incredible. Sounds much better than Higher Education Relief Opportunities for Student Act. Like, a lot of those words are in there just to make heroes. You could say it in a lot fewer words.
Well, and the most famous example of this was after 9/11. The House passed the USA Act and the Senate passed the Patriot Act, and they put them together to form the USA Patriot Act, which every one of those letters stands for something. And I'm going to get some of them wrong, but it's basically United Strengthening America by providing adequate tools. Oh, I can't remember what the rest of it stands
It's literally
for.
Mad Libs for the legislature.
Yeah,
I only mention that because it's always like tickled me to no end that we have these incredibly long act names. And here's why it's important. When we write briefs on these cases, like you ultimately shorten it, but you have to get it right the first time. Like the CARES Act for COVID relief, I had to write the CARES Act over and over, and I still don't actually know what CARES Act stands for because I'll always shorten it and just call it the CARES Act. So it tickles me to no end, and lawyers are kind of, one of those site checking things. I'm always like, is that the right word? Because none of this really means anything. It literally is a word salad. So that aside, we're talking about the
here's
HEROES
what
Act.
the USA Patriot Act. I looked it up.
Please.
United in strengthening America by providing appropriate tools required to intercept and obstruct terrorism. Act of 2001. So, and the CARES Act is Coronavirus Aid, Relief, and Economic Security Act.
That's an art form to basically come up with these acronyms. But let's talk about the HEROES Act. And you pointed out something that is very important and how these kinds of cases basically end up in our Supreme Court. These statutes are passed for whatever reason, right? This was not passed in 2022 when it was used to forgive about $1 trillion ultimately in student loans. Oftentimes we have these statutes that are out there, and then you have an actor. Any branch of government wants to do something. You know what's really hard is to get something passed through Congress, right? It takes a long time. There's a lot of politicking. But if you want to act right away, one of the best chances of doing so is to see if you could essentially work through an existing statute. And that's what happened here. So it's not surprising that this act has been around for, 15, 16 years. Almost 20 years before it was used for this purpose. And it's in those test cases when you're kind of on the fringes, if not completely outside of the act, and we'll talk about that, and you're testing the bounds of that act, that it becomes a legal issue. And these types of cases, you can spot them a mile away. We knew when President Biden did this, it was going to end up at the Supreme Court. This is just the type of case that is the perfect test case for, does this statute allow this? Does the Constitution allow it? And ultimately, it will have to be the Supreme Court who has the supreme word on it. So let's talk about the HEROES Act, because the HEROES Act, as I said, wasn't passed in 2022. It wasn't passed in response to COVID. It wasn't passed in response to some study about how much student loan debt millions of Americans were under. In fact, it was passed in response to 9/11. It read in relevant part that the Secretary of Education, quote, may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under Title IV of the Education Act as the Secretary deems necessary in connection with a war or other military operation or national emergency. In response to COVID-19, the Secretary of Education in the Trump administration used the HEROES Act to suspend loan payments during the duration of the pandemic, making use of, you'll notice what I just said, a national emergency. So COVID-19 wasn't a war, it wasn't a military operation, but there's kind of this catch-all at the end of the HEROES Act that I just read that said, or a national emergency. And so this is important to note because a lot of people think, oh, this is just starting with Biden. No, this actually goes back to President Trump's administration. So that suspension of payments has not actually been lifted since the Trump administration, and repayments are due to begin in October, so in about 2 months.
And apparently they're going to begin, but it's going to be sort of a soft ramp up. So they're not going to, if you can't pay initially, they're not going to charge you interest and all this other stuff, which sort of goes to this flexibility that you have under this. Now, the COVID emergency has ended, so there's some question about how much flexibility you have left with this, but that's a separate subject. And this is not the only change they made, and one of them really benefited me because there is a public service loan forgiveness program that's supposed to be, if you spend 10 years or something in public service, your federal student loans will be forgiven. And they tell you that when you're in law school, and it sounds great. And then, you know, at some point you realize that there are all these hoops you had to jump through at the beginning to make sure that your payments were counting all that time. So invariably what would happen, you'd have these people who were in public service. They'd spend 10 years in public service, and they would say, hey, I've been in public service for 10 years. I would like to forgive my loans. And the loan servicers would say, well, sorry, you didn't check this box and click this thing and sign this document back when you started, so none of that counted. But if you want to start now, you can. And of course, you're 10 years into it at that point. Well, one of the things they did was they used this provision about modifying and waiving provisions to change that, and basically made it that any loan payment that you made while you were in public service would count towards your 120 payments, 10 years, 120 payments you had to make for loan forgiveness. So whereas I had not been eligible for it before, all of a sudden I was, and was able to file the thing, send it off, been in public service for 10 years, loans forgiven. Not only were my loans forgiven, they paid me some money back. So it was like a nice situation. And so you have sort of these escalating things, waiving payments, waiving certain requirements that had applied to forgiveness programs before, and it's sort of escalating up. And eventually, this leads to the ultimate question. If you can do this, if you can change these terms in this way, can you just cancel the loans altogether? Can you just say, you know what, never mind, you used to owe us a bunch of money, now you don't? And in 2020, this actually went to the Office of General Counsel in the Department of Education, and they looked at the HEROES Act and concluded you couldn't do that. Didn't go that far. But then when President Biden wins the election, all of a sudden you got totally new people in, and he says, hey, take a look at it again. So now the Office of General Counsel looks at it, and they end up rescinding that memo that said you couldn't do it and said, in fact, you can do it. New memo reaches the opposite conclusion. So new memo in hand, the Secretary of Education then moves forward with the debt cancellation plan. And like with most things, this had been something that had been discussed in the legislature, in Congress, in public about doing something about student loans for a long time. But as Alice said, it wasn't going anywhere. It had a lot of gridlock. Nobody could decide exactly how much you should be forgiving, who should get it, who shouldn't, what should the income levels be, how big should this be? Should it really only be for people who are really not making a whole lot of money at all, or should it be for everybody? And it just wouldn't go anywhere. And so at some point, when it was clear nothing's going to happen legislatively, that's when you have the executive branch kind of step in and say, okay, fine, Congress is not going to do anything. We're going to step in and we are going to act.
And so the question for the Supreme Court was a statutory interpretation question. It's whether the words waive or modify in the HEROES Act meant cancel. The court started by citing prior precedents and dictionary entries for the principle that modify has a connotation of incremental change. By the way, statutory interpretation is like a class that I think every law student, it's either a class or a method of interpretation that you learn in law school. And this is like statutory interpretation 101. What does a word mean?
And, we did legal briefs on it.
We did legal briefs on it. And one way to do that is to look at the definition and also common usage, the time in which it was adopted, how it was used, how is it used now, how is it understood? And the reason you do that is because the law wasn't passed by one person, obviously. It's passed by many representatives, and everyone may have a slightly different understanding of the word, but they worked as a body. All these hundreds of people worked as a body to pass this law. And so that is one, that's the legislative branch. The judiciary, which is a separate branch, this is where the separation of powers comes in, has the power to interpret that word as it is passed. So what does waive or modify mean? And the court noted that the statute itself specifically limited the power of the secretary to discharge debts to things like death and fraud. On the other hand, the secretary's actions had, in the words of the court, modified loan debt, quote, in the same sense that the French Revolution modified the status of the French nobility. It has abolished them and supplanted them with a new regime entirely.
And that's, typical Supreme Court. When you read Supreme Court opinions, they often have these sort of flowery analogies, which, that one was pretty funny, frankly, the modifying the French nobility. You may recall that during the French Revolution, the way they modified the French nobility was they cut off their heads. So, that was I don't know what clerk wrote that, but it was pretty funny. Okay, so faced with this, and you have these arguments, and there's briefing going back and forth. By the time you get to the Supreme Court, you've already argued this in front of a bunch of courts. Kind of know what your arguments are going to be, and you know what the responses are going to be. So the secretary knew this was coming, and so they argued, okay, fine, look, if you think modify is too weak, we also have the waiver language, and waiver is broader than modifying. Unfortunately for them, as the court pointed out, waiver, if you read the statute and read the text, it refers to provisions. So you can waive provisions of the law, not debts. So it's not saying you can waive debts. If it specifically said that, that would obviously be very powerful for the secretary. And there was no provision of the law the secretary was waiving. And the secretary had exercised waiver before, but every time he'd done it, it had been in regard to some provision. So the government, the Biden administration, in arguing about this, they see this as coming, so they concede that point. They say, look, we're not saying, and this is where this stuff gets complicated when you're in the Supreme Court, we're not saying the secretary can waive the loan balance itself or the obligation to pay. Rather, the government said, it was waiving the elements of discharge and cancellation that would normally be applicable. So there are certain ways you can discharge or cancel a loan. I mean, one of them might be we talked about this, the public service loan forgiveness. There are fraudulent provisions. If you take out a loan and you go to a school that turns out was engaged in fraud, and there's the Corinthian schools, there was a big scandal. And those turned out to be fraudulent, and the people who had taken out loans to pay for that, they had their loans forgiven. So what the secretary essentially said was, look, we can't waive the loans, but we can waive all the provisions that you would normally use to get relief through that. So public service loan forgiveness says you have to serve in public service for 10 years. We'll just waive the 10 years part and waive the public service part and forgive you under that. That was essentially what they were arguing. The problem was the court, who's already said, we think you're playing kind of fast and loose with these words, was probably never going to go with that. And the court was not impressed and called this sleight of hand in their attempt to use the waiver language to forgive the loans altogether.
And look, you got to hand it to them. This is why really good appellate lawyers are really good. They're getting at the same conclusion that they want through a different route, because they see that it's a losing argument to say we're just going to cancel the balance, but they're getting to the same result through a different avenue. The majority explained that its overall point is related to the separation of powers. It explained, quote, "The question here is not whether something should be done." That's a political question. "It is who has the authority to do it. When the power claimed is broad and expansive, the court looks more skeptically at the interpretive creativity necessary to justify it." And I think this is a really important point that gets lost in media coverage. So the Supreme Court is not charged with deciding whether it's a good idea to cancel student loans, or whether student loans are too high, or whether student loans have been abusive, the way that it's been administered in the past, and that people are stuck in these cycles of having to pay back loans that they truly can never pay back based on their salaries. They are not part of the political thicket in that sense. That is for the legislative branch, they will say, or even the executive, but it's not for the judiciary. All they are charged with doing is, does the separation of powers allow this? Which branch of government is tasked with deciding if that's even a good idea? And if it's a good idea, which branch of government is supposed to be the one to execute it? Because all of that power doesn't reside with one branch. Otherwise, there would be no checks and balances. So in this case, the Supreme Court, the majority continued, quote, "The Secretary of Education claims the authority on his own to release 43 million borrowers from their obligations to repay $430 billion in student loans. The act, which has never been used in this way, couldn't support such an expansive claim of power," said the majority. The court even quoted Speaker of the House Nancy Pelosi, who said in 2021, quote, "People think that the President of the United States has the power for debt forgiveness. He does not. He can postpone, he can delay, but he does not have that power. That has to be an act of Congress." And those words apply no matter who is in office in the executive branch, because this is ultimately a question of which branch of government, not who sits in the seat of the executive.
And this is something that is really old. This is a really old theory that the Supreme Court is working off of. In the wake of the Second World War and during sort of the period around the Korean War, there was something called the steel mill cases, where the president attempted, I forget exactly what he was trying to do, if he was trying to commandeer the steel mills to make them produce certain things or what. And it went up to the Supreme Court, and the majority said you can't do that. But then in a concurrence, Justice Jackson, who had been the lead prosecutor for the United States at the Nuremberg trials, wrote this concurrence that really kind of became, sometimes just because you didn't write the majority, nobody reads the majority in the steel mill cases. Everybody reads the concurrence by Jackson. And what he essentially said was that the president's power is limited by Congress. There are certain areas where the president can act basically without limitation, but they're very limited. Things like the war powers are typically in the president, though the president can't declare war. He has to do that through Congress. And it set up sort of a tripartite test. One was where Congress has acted and said the president can do something, the president's power is at its maximum. Because Congress has acted, it's granted the president certain power, the president is acting that way, that's the maximum authority the president's ever going to have. Then there's sort of a second level where Congress has acted, but it's a little bit of a question about what exactly Congress was doing, what powers it was giving the president, and there's sort of an open question, kind of where we are in this. And there, Jackson said, going to be a lot more circumspect about what the president can do on his own. And then there was where Congress hasn't acted, or where Congress has, in fact, acted in the opposite way and said you can't do something. Then the president really needs to be relying on specifically enumerated powers in the Constitution if he's going to be able to do that. This is a branch of a couple different things that are really complicated, and we could spend an entire law school class on the non-delegation doctrine, which says Congress can't just delegate all its authority to the president. Congress can't just pass a bill with really broad language and all of a sudden the president can just do whatever he wants. Obviously, we don't want that. We don't want an enabling act, essentially. We don't want Congress to be able to pass enabling acts that make the president essentially a dictator. And that's been refined into something called the major questions doctrine, which is if the action the president is taking is a big one with a big effect, and it's going to have sort of sweeping changes. That's going to be a major question. In much the same way as the steel mill cases, the president really needs to be able to point to something that Congress has done giving him the authority to do that. And it can't be one of these sort of creative, like, well, there's some words here that if you look at them just the right way, the president can do whatever he wants. And that's essentially what the majority is saying in their opinion. But there's also a dissent in this case. The dissent was written by Justice Kagan, my former law school dean, who I once shared a drink with. She always liked to call Harvard the Manhattan of law schools because it was big and it was diverse and all these other things. And so one time I was in an event with now Justice Kagan, and I had a Manhattan. I was drinking a Manhattan, and she said, "What are you drinking?" And I said, "I'm drinking a Manhattan." And she said she'd never had a Manhattan before, and I was shocked and horrified with all her language about Harvard being the Manhattan Law School. So obviously I let her try it, and she loved it. And so, that's the only time I've shared a drink, literally shared a drink with a Supreme Court justice. But most of y'all can't say that you've done that, can you? Anyway. So
Of course, your experience with a Supreme Court justice is not in the legal realm, but of sharing an alcoholic beverage.
Exactly. It was amazing. So Justice Kagan, she's really smart, and I love reading her opinions, and she wrote a dissent in this case. And essentially, her dissent kind of just takes the opposite position of the majority, and that may seem obvious, but that's not always true. It's not always true that the dissent is in direct opposition to the majority. But here, she really just says, look, modify and waive, those are broad. Those are broad words, and they're broad enough to allow the secretary to do this, to cancel debt altogether. And so, frankly, we should just let them do it, right? Like, they're broad terms. Let them do it. Now, really, the dissent spent most of its time on standing because the entity that challenged the action is called MOHELA. They actually were my federal loan servicer before my loans were forgiven, and they're run by the state of Missouri. And the dissent argued that the state of Missouri, who was one of the states that brought the suit, really wasn't going to lose any money if the action went through. This was complicated, and standing is boring. So if you're interested, go read the opinions, both the majority and the dissent's discussion of it. Y'all can decide whether or not you think which side had the better of the standing argument, but still trying to keep people listening to the show. So we're not going to talk about standing too much, but it was an issue that was a big deal. The majority didn't spend a whole lot of time on it. The dissent did. And the dissent's argument, other than standing, was pretty straightforward. The language of the statute is broad enough to allow the secretary pretty much unfettered power when it comes to loans. And the key portion of the dissent that you either buy or you don't is this one. To waive or modify a requirement means to lessen its effect from the slightest adjustment up to eliminating it altogether. And this comes back to sort of what we were talking about at the beginning and why this is an interesting case. Because depending which way you view this really is a window into how you view federal power, and in particular, who holds that power. If you think that Congress should be doing more and Congress is in a check on the executive, and we need to make sure that laws are pretty strictly interpreted, you're going to be on the majority side. If you're kind of sick of the gridlock in D.C. and you feel like the executive should just be able to cut through it and use whatever's in the laws to do that, you're going to be more on the dissent side. The one thing I'll say about the dissent, there are a lot of laws. There are a lot of laws, and they're poorly drafted, and they're often broadly drafted. So if you take the dissent's view to its logical conclusion, the power of the president is going to be even more vast than it is now. I'm always reminded of the scene in Star Wars Episode 2, Attack of the Clones, where Anakin and Padme, they're like sitting in a field, and Anakin is talking about how much he hates sand because it gets everywhere. And at some point, they start talking about the Republican Senate. And Anakin's complaining about the gridlock and how they can't get anything done, and how he just wishes there was somebody who could just force them to agree so they could make life better for everybody. And Padme's like, that sounds like a dictatorship. And Anakin's like, well, maybe that's what we need. And it's just, a very simplified argument about power. But that's kind of what we're having here. We're having that argument about whether or not you should be able to sort of fix these problems by circumventing what you would think is sort of the normal process of taking a bill to Congress and saying, hey, let's forgive $500 billion worth of student loans, getting it passed and getting it signed.
So when you were going to give a quote, I did not know you were going to do Star Wars. I thought we were like tracking on the same wavelength and you went a whole different direction because what I thought you were going to say is one of my favorite quotes from A Man of All Seasons, for all seasons, all seasons.
This is the difference between Alice and me. She's doing A Man for All Seasons. I'm doing Star Wars.
When you said Star Wars, I was like, my brain was like, skirt. We were not on the same wavelength and I thought we were tracking. So a really great way to think about this as well. Remember, if you think the dissent has it right, and it's not just about whether loan should be forgiven, but who holds that power, it's important to recognize that you don't get to kind of take away that power when you don't like who's sitting in the executive branch. So that expansive power would extend to every executive, whether it's the president you voted for or not, and in perpetuity, and with more and more laws as they get interpreted in this way, because there's precedent to say, you know what, all of this power does go with the executive. There can be delegation of these major questions. So keep that in mind. And why I thought you were going to quote A Man for All Seasons is I'm going to read this quote. If you've seen it, you've probably heard this quote before. It's often used to describe about why we care about laws. In the constitutional context, in the criminal context, it's just, I can't say it better myself. It starts with William Roper saying, so now you give the devil the benefit of law? Sir Thomas More, yes. What would you do? Cut a great road through the law to get after the devil? William Roper, yes. I'd cut down every law in England to do that. Sir Thomas More, oh? And when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat. This country is planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil benefit of law for my own safety's sake. And so that quote is often used to describe the constitutional protections in the criminal context, and you can see why, right? When we're saying, oh, this person shouldn't get a jury trial, or this person doesn't get another appeal. They've already had so many appeals. And the purpose is that these protections exist, especially in the instances where you disagree with them, so that when you zoom out and recognize that we have an entire legal system that is interconnected, that we live in a jurisprudential legal system, right? This case's reasoning will be used for the reasoning of interpretation of other laws. Perhaps one that has an outcome that you would side with the flip-flop, right? And the thing is, we have to make all of these laws and all of these constitutional interpretation questions apply across all of these different applications, which is why I thought you were going to quote that and not Star Wars.
Well, I mean, I'm a man of the people, Alice. Sometimes, you Yale people talking about all these fancy. At Harvard, we were much more down to earth when up there in their ivory towers in New Haven. That's why all of y'all go into academia and we become public servants. So
that was such beautiful pontificating.
So beautiful. And look,
go ahead.
I was just going to say, this issue that we're talking about is becoming sort of the defining issue in the courts and in the way you view the executive. The executive has always been powerful and has really accrued more and more power to itself, particularly since, after September 11th, we talked about the USA Patriot Act, the executive gained more and more authority. And it did so in the Bush administration. It did so in the Obama administration. At one point, President Obama was complaining that Congress wouldn't pass a law, and he said, well, I've got a pen and a phone, and I'm gonna take care of it myself. And he did some things where there were attempts, for instance, to pass immigration reform. It didn't pass, and so he said, well, fine, I'm just going to sign an executive order. There were attempts to pass some sort of rehaul of the Environmental Protection Act. Couldn't get it done, so once again, executive order. And these things all end up in the courts. They get fought out. Sometimes they make it through. Sometimes they don't. In the President Trump's administration, you saw this a lot. Think of sort of the quote unquote immigrant ban or the Muslim ban. I forget how it was described at the very beginning of his administration, which was based on a reading of an act from like the 1880s or something, right? And this question of how much authority do you want to give the president, whoever it is, to act on their own? And as Congress, frankly, remains very much gridlocked. I mean, there's just not a lot coming out of Congress. More and more focus will be on the president, whoever it is and whatever party they're from, to act to solve problems that Congress seems incapable of doing. One bright spot in this is when COVID happened, there was some bipartisanship. Like we talked about the CARES Act. It solved a lot of problems we were facing in the courts. We'd never seen anything like this. We'd never had courts closed by a pandemic before. What are we going to do? There's all these statutes that require things like you appearing in person in court. Can't do that, but we also can't just shut down the justice system. Congress responded and in a bipartisan way passed something to fix that, but that's rare. And it really kind of takes the end of the world to make it happen at this point. And so you're going to see more and more of this. And this is an issue that's going to go up to the Supreme Court over and over and over again.
And that's a great point, Brett. A lot of people who are paying attention to the legal news have asked this question a lot. And it's a very good question. Gosh, why are we hearing about the Supreme Court so much more now? Why are all these really hot political fights in the judiciary? I thought they were supposed to be apolitical. They're supposed to be the least dangerous branch. What's happening? And, one theory that's happening is because we have such gridlock in DC, that the legislature is so political that nothing gets passed. And so the attention turns to the other branches, not just the executive, but the judiciary, to basically make things happen when in fact, that wasn't the original design. And then the question is, think about a project you're on. If there's 3 members of the project and one of you is just a complete slacker, it's a good question to ask. Do you just let the slacker get away with it and the other 2 pick up the slack and let the third one ride along when extrapolate this out to the entire nation? Is that what you're supposed to do? Or are you supposed to say, hey, lazy guy, pick up your part of the deal. This is, a tripod. We can't do this project with just the 2 of us. And that's part of this ever ongoing debate, right? In a lot of these opinions, both ones that have been appointed by Democrats and appointed by Republicans who sit on the Supreme Court have pointed out many times, hey, Congress, get your act together. If you want to do this, pass the law. And they say that because they recognize there is gridlock, and it is, I don't know what the answer is for it, but it's an interesting point to note that these questions are being highlighted in the executive branch and in the judiciary, partly because of all the gridlock that we see.
And, I often think of Plato's Republic when you think about this. And Plato had this sort of hierarchy of forms of government. And Plato, we all would not agree with Plato what he thought the best form was, but nevertheless, we have a Republican democracy, right? So we have a republic that's kind of a democracy, and, it's not a pure democracy. It's not as democratic as maybe Britain would be, and it has Republican structures built on top of it to prevent pure democracy, which people like Plato and people who were informed by him thought was the worst form of government because it was ruled by the mob and they didn't want to do that. But some of the forms of government that he criticized, dictatorship. If you have a president who's doing everything, you're close to a dictatorship. But the other one is oligarchy, which is a rule of a few people who think they're basically better than everybody else. And if it's the courts that are going to be doing it, you're going to have an oligarchy. I mean, that's what the courts are. If suddenly they are the ones making all the decisions, and the executive branch and the judicial branch have been incredibly active over the last 20 years. The legislative branch has not. The legislative branch has basically fallen apart and has abdicated more and more of its responsibility to both the courts and the executive. And that is a recipe eventually for disaster. So, like Alice said, we can warn you about it, have no idea how to fix it. But it is definitely a problem. And I just think you're going to see it more and more in the years to come. I don't think it's not going to change until Congress reasserts itself and becomes what it's supposed to be. This is something you're just going to see every year. Massive decisions about how our country is going to function will be decided by the Supreme Court deciding whether or not the executive can do the thing they did. Not Congress making decisions after debate and voting and passing laws. And that's not how decisions will be made. It will be made by the oligarchy checking the dictatorship. And that is not the way it's supposed to work.
That's a good one to know to end on, actually. I feel like we just teed up another legal briefs, but that'll be for another time. With that said, since this was super easy and super undense, is there anything you'd like to add before we sign off for the day, Brett?
The one thing I'll say, we've been doing 5-star reviews for the other podcasts. We should do that for this podcast as well. So if you've already asked your one question on the other podcast when you left 5-star review, if you leave a 5-star review on Legal Briefs, add a question, and we will answer that question as well. So we'll just start doing that for both shows. So leave those 5-star reviews, leave your question, and we will answer them.
Absolutely. And as always, you can reach us on all social medias, Twitter, Facebook, Instagram. You can email us at prosecutorspod@gmail.com. And we are here live often with our patrons. So thank you guys for supporting us and for listening. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. I'm on the right setting. Look at me. Okay, there's that. There's this. My notes. I am ready.
You're ready.
Oh. Ooh.
Hello, everybody.
Hello.
I feel like these are our hardcore.
These are our
hardcore
hardcore
people.
fans, despite scaring everybody off yesterday.
I know. And some people just couldn't handle the truth about the moon.
Oh my goodness. Oh my goodness.